Good morning and welcome to Gough Square Live. For those who don't know me, I'm Lee Finch and to my left is Thomas Samuels. This morning we'll be discussing the new Debt Recovery Pre-Action Protocol, which is due to come into force on the 1st of October of this year. As always with our interactive seminars, we'll be running a live feed at the same time and throughout the broadcast. If you have any questions or simply want to compliment Tom and I on how good we look on camera, please do get in touch. You can do that either on the live feed or by emailing goughsquarevl@gmail.com. That's goughsquarevl@gmail.com. The format of today's broadcast will follow that of previous broadcasts. In a few moments I'll wrap up these introductory comments, following which Tom is going to take us through the new debt protocol, taking about 15 minutes to do so. During that time I will man the live feed and will respond to any questions as appropriate. Any questions I consider to be too difficult or too complicated to deal with on the live feed, I'll hold over to the end and Tom and I will discuss them at that point. And by discuss, I certainly don't mean that I will ask the questions and Tom will simply answer them. As promised, that brings me to the end of our brief introduction, and I can hand over to Tom to do the hard work.
Good morning, everyone. I'm going to be talking to you this morning for a few minutes about the forthcoming pre-action protocol for debt recovery claims. We're going to look at it in 4 sections. First of all, an introduction, who, what, when and how. Then what is to be done by the creditor under the protocol. And then we're going to look at the nature of the debtor's response. And then finally, a few consequences or other points to consider in light of the obligations. The purpose of this broadcast, I should say at the beginning, is not to recite exactly what's written in the protocol. It's clear and it's fairly easy to understand from the written text. Really what we're going to be doing in today's session is looking at some of the more interesting details and the consequences which flow from them. So could I have the first slide, please? So you'll see on the first slide what we're looking at here is when the protocol comes into force, who it applies to, why it's been created, and how it operates. Thank you. So the protocol comes into force from the 1st of October 2017. I don't wish to ruin anyone's summer holiday, but there are 122 shopping days to Christmas, which means that the 1st of October is only 5 weeks away. So it's important to start thinking about this protocol now in terms of the content of the letters and the processes and the procedures that might need to be put in place by creditors as we lead up to that start date. It's important to be able to get into the habit of sending out the letters at the right time and to get a feel for what's done. So even though it's not in force, it might be worthwhile just as claims are beginning to come into the pipeline now to start sending out these sorts of letters and getting together the relevant sorts of information. In terms of who the protocol applies to, debt recovery is actually slightly a misnomer because it's not in fact that wide. It's not going to apply to a $10 billion claim made against Gazprom, for example. What it's really aimed at is litigation between a business and an individual. Those terms are at least partially defined within the protocol itself. For a statutory lawyer like myself who looks at definitions, they are a little unusual because business is said to include a sole trader and a public body, but at the same time individual is also said to include a sole trader. So although it refers to a business and an individual, in certain circumstances one is going to be looking at a claim by one individual against another individual. Inevitably there's going to be a great deal of overlap between claims covered by the protocol and loans which come within the Consumer Credit Act 1974. I would say, however, and it's very important to emphasise, that they are not coterminous. Merely because the Consumer Credit Act doesn't apply to the loan, that doesn't mean the protocol won't apply, and merely because the protocol does apply, that doesn't mean the Consumer Credit Act will apply. Although there is a lot of overlap, that must be borne in mind, and it can't simply be assumed that because one applies, the other does also. So in terms of why the protocol exists, it sets out 4 reasons within the text, and they're the standard 4 reasons that apply to all pre-action protocols, in fact, so they're not unique to this particular one. They are firstly to encourage engagement and communication between the parties, secondly to enable the parties to resolve the matter without the need to start proceedings, thirdly, to encourage the parties to act in a reasonable and proportionate manner, and finally, to support the efficient management of proceedings in the event that they cannot be avoided. Now, it's important to note, and we'll come back to this, that although those appear in all pre-action protocols, given the underlying purpose and the context of this particular pre-action protocol, they're perhaps not quite as applicable here as they might be in other situations. So finally, on this slide, how does it work? We're going to look in the next two slides more specifically at this in terms of obligations on the creditor and on the debtor. At this stage, however, it's just worth noting paragraph 1.3 of the protocol. It's intended to complement any other regulatory regime which might apply. So it envisages here things like the Consumer Credit Act. It specifically mentions the Financial Conduct Authority Handbook. In particular, I would imagine the conc rules are what I had in mind. And it says that it should be read in conjunction with those, and it aims to complement them. However, as a catch-all, just in case the Ministry of Justice haven't quite drafted it as they might have hoped, it says that insofar as there is an inconsistency, those regulatory regimes take precedence over the terms of the protocol. Could I have the second slide, please? So in this second slide, we're looking at the business which is proposing to sue on the debt in question and the obligations which fall upon it under the terms of the protocol. And those are dealt with at section 3 of the protocol. Thank you. Paragraph 3.1a sets out the 8 things which have to be included in a letter before action under the terms of the pre-action protocol. And as I said at the outset, I'm not going to go through them in detail and simply recite a list, but broadly what they're aimed at is ensuring that the debtor understands the amount of the debt, where it has come from in terms of the parties' agreement, and how the debtor can take steps to attempt to resolve the situation, whether it be by payment plan or whether it be by some further discussion of the legal issues which might arise. One particular factor is of interest that I'm going to flag up, and that is the item to be included under Little Roman numeral 4. Details of the written agreement, which gives rise to the debt, if any, including the fact that a copy of the written agreement can be requested from the creditor. Now, in my view on the reading of this, it has some potential interaction with sections 77, 78 and 79 of the Consumer Credit Act, which of course set out similar rights for agreements regulated by that statute. A question might arise as to whether a creditor could say, well, you have this right under section 77 of the Consumer Credit Act, and so if you want a copy of your agreement, we're going to ask that you proceed by way of that provision. It seems to me that probably a creditor could not do that, and I say that for 2 reasons. First of all, this protocol is aimed at cooperation and open communication. To force a debtor to go down a statutory route where it is available is probably not quite in the spirit of that. Creditors should get used to giving this sort of information and to be open with the way in which they communicate with potential defendants to debt claims. The second is that sections 77, 78 and 79 in fact go a little further. They of course require the payment of £1 by the debtor, and they also include the requirement to give a signed statement of account and any other document referred to. So it's really there for a different purpose. It has very specific statutory consequences, which we will look at in due course. The next thing to look at in terms of what the creditor has to do is at paragraph 3.1b, and this relates to interest and charges. And so attached to the letter before action, the creditor has to set out an up-to-date statement of the interest and charges which apply to the debt. This can be done by way of a statement of account if that's available, whether it be an up-to-date statement account or a recent one which is updated with the most recent interest and charges, or if there is no statement of account at all, simply a breakdown. And really what this is aimed at, it seems to me, is that those can often be significant sums added to a debt. So if one takes a loan for £10,000, occasionally you'll see another £5,000, £6,000, £7,000 worth of interest and charges that have racked up. And it's that sort of additional money which will often be the cause of the dispute between the parties. And so it gives the debtor the chance to understand how that figure is broken down and to really focus in on points, if any, that they might wish to take in relation to them. The final point on this slide is the nature or the method of dispatching out the letter before action. It must be done by post, unless the debtor has made, and the words in the protocol are an explicit request that they do not receive communications by post. Now, for the avoidance of doubt, a lot of lenders nowadays use online platforms where they upload their terms and conditions, or they upload statutory notices, or default notice, or whatever it might be, or perhaps they might have a contractual term which permits them to serve certain documents by email. However, those will not constitute an explicit request for the purposes of this. There must be something specifically which says do not contact me by post. So it must be posted out. The final point on that is that the CPR ordinarily refers to first class postage. If you look at CPR 6.31b, so the question arises as to whether or not it has to be sent out by first class post. I had a discussion with someone else in Chambers about this the other day. I describe it as interesting, but my definition of interesting is probably slightly different to other people's. There's no specific mention of whether it has to be by first or second class post, so probably either is okay. However, there is clearly an obligation to get the letter to the debtor as soon as reasonably possible, because it refers to sending it out either on the day on which the letter is dated, or if not reasonably practical, the day afterwards. Could I have the third slide, please? So under the third slide, we're going to look at the nature of the debtor's response, which is dealt with by certain documents, pro forma documents, which are simply annexed to the protocol, in terms of the timing of the response and what rights the debtor then has upon receipt of the letter. Thank you. Again, I'm not going to go into the detail of this, but the debtor's response really gets to the heart of this pre-action protocol, it seems to me, in terms of what it's there for and what it's aimed for. And it is different in its nature to a lot of other pre-action protocols under the CPR. For example, it doesn't set out in any great detail what a debtor should put in his or her response. Equally, it doesn't include a time limit. For example, under the, I think, clinical negligence claims pre-action protocol, there is an initial response time of 14 days by the would-be defendant, followed by a 4-month period for full investigation. There is no explicit timescale for the debtor. Instead, what is said is that if the creditor doesn't get a response within 30 days, he is then entitled to issue a claim. And indeed, all of the obligations are really couched in terms of what the would-be creditor must do, rather than what the would-be debtor doesn't do. They can issue proceedings after 30 days, as I've said. If the debtor is seeking debt help in the letter, reasonable extra time should be allowed. If the debtor requires time to pay and an agreement is reached, but it's subsequently breached, so if there's a payment plan put in place and it's then breached, then the whole pre-action protocol process simply starts afresh, as per paragraph 6.4 of the protocol. And so what the debtor's response, section 4, really illustrates is that this is not really aimed at equal communication between the parties. It's effectively a consumer protection measure. It's there to stop people being sued for their debts, either by way of discussion or to make sure that the creditor has all the necessary information to take an informed decision and to do whatever they can to try and work out another way to help this would-be defendant pay the debt rather than simply suing them. And that really is the distinction between this and the other pre-action protocols. And that's illustrated, in my view at least, by the last bullet point on this slide about the debtor's right to pre-action disclosure. A debtor, upon receiving a pre-action letter, has a right to seek any document or information, and the creditor must provide it or explain why it is unavailable within 30 days of receipt of that request. So effectively, this gives a carte blanche, apparent carte blanche right to seek pre-action disclosure. So again, it's all about the debtor having the full information and being protected insofar as possible before a claim is issued. However, that said, it seems to me that it can reasonably be read into that obligation that the request cannot be a fishing exercise, it cannot be disproportionate, it cannot be irrelevant. I'd have thought that a creditor who applies a similar sort of test to that kind of request that would apply to pre-action disclosure in any event would not be criticised by the court. It would be open to them to refuse on the basis that the information sought or the documents sought are simply irrelevant to the likely nature of the dispute going forward. The right to seek pre-action disclosure under this paragraph 5.2 also plays back into sections 77, 78 and 79 of the Consumer Credit Act, because it allows a debtor to put together a similar set of documents that could be requested under those sections, but without having to pay the £1 fee. The important difference is that, of course, if the creditor under this disclosure obligations doesn't provide them or incorrectly provides the documents or provides the wrong documents, the statutory sanctions won't apply. It's that £1 payment under the Consumer Credit Act which is the gateway to the statutory sanction which then applies. So could I have the fourth slide, please, then? So finally, under the fourth slide, having looked at those various obligations, there are a few additional points to consider which flow from the protocol in terms of purpose, non-compliance and limitation. I'm actually going to switch the second and third bullet points and look at limitation first, and then consequences of non-compliance along with the recent Gelvora case. Thank you. So I've already dealt with the purpose and how the context and the purpose of this pre-action protocol is rather different from some of the others. It's not necessarily about an equal form of communication between two parties to a dispute. It's very much more about avoiding litigation against individuals and doing what is necessary to help the individual pay the debt without resorting to court proceedings. In terms of limitation, I pick this up and highlight it because, as I said, there is the possibility of almost a vicious unending circle of pre-action protocol compliance. Because if I were to be suing someone and I sent them a letter before action, in response to which we agreed a debt plan, they pay that debt plan for, say, 2, 3, 4 months, and then it breaks down and they stop paying. The pre-action protocol specifically says that I must then begin the protocol process afresh. And so this could lead to one pre-action protocol that lasts 3 or 4 months, and then another, and before one knows where one is, you've got 2 or 3 years down the line of broken promises and the limitation has been and gone. This is not expressly dealt with in the protocol, but it is dealt with in the practice direction, which applies generally to all protocols. And that is at paragraph C1-009 of the most recent edition of the White Book. And what it says is that protocols do not stop the running of time for the purposes of the Limitation Act. Time will continue to run, and so one must always keep an eye on the limitation period which applies. If in any doubt, the correct thing to do is to issue protective proceedings and to immediately apply to the court for a stay in order to facilitate compliance with the pre-action protocol. In the example I gave, it's a little facetious of the never-ending compliance as a result of broken promises. In that sort of situation, it's likely that probably one wouldn't need to stay. If the debtor has had sufficient number of chances to comply and they haven't done, then at that point it's probably legitimate to say, we're not going to do this again, let's just get on with it. In terms of consequences then, consequences are dealt with at section 7. Pre-action protocols, unlike statutory or other regulatory obligations, are concerned with substance and spirit of compliance rather than technical compliance. So it's made explicit that any technical or minor non-compliance will be overlooked by the court. What the pre-action protocol is relevant to is costs at the end of the matter and general case management during the course of it. And that applies to all pre-action protocols as well as this one. However, for debt claims, it seems to me there are 2 potential additional factors to be considered. The first is the recent decision of Gelvora, which I referred to in the final bullet point of this slide. And this was a Court of Justice of the European Union decision that came out, I think, towards the end of last month. It involved a Lithuanian private debt collection agency who brought actions for recovery and in parallel also sought private enforcement by bailiffs. There's not a lot more detail in the decision about exactly what they did, but what it decided is that debt collection is capable of coming within an unfair commercial practice for the purposes of the Unfair Commercial Practices Directive, which is put into force in this country by the Consumer Protection from Unfair Trading Regulations 2008. So be warned, it's possible that inappropriate debt collection, whether it be aggressive or misleading, could be a criminal offence under those provisions. It could be subject to regulatory action, or potentially it could give rise to a private cause of action under Part 4A of the 2008 regulations. In addition, for consumer credit agreements, there is, of course, the overarching principle of the unfair relationship. It's explicit under Section 140A(1)(b) of the Consumer Credit Act 1974 that within unfair relationships are the way in which the creditor has exercised or enforced his rights, and clearly compliance with pre-action protocols and giving all of the right timings would fall potentially squarely within that. So as well as the usual case management civil procedure obligations or consequences, if one ignores this pre-action protocol, it may be that it could be used to bolster or to support some other kind of counterclaim against the creditor, which is rather unusual in comparison to other pre-action protocols. So that brings me to the end of my 4 slides. I'm now going to turn to Lee and see if we have any fascinating questions that have come in by email.
Yes, Tom, we've had a few questions. Firstly, you referenced earlier explicit consent.
Yeah.
And we've had a query asking about the interplay between that and Section 176A of the Consumer Credit Act, which deals with consent required to have valid service of documents electronically in regards to Consumer Credit Act provisions.
Okay, well, I think probably what that's referring to is 2 points. First of all, the sorts of terms and conditions that I mentioned, I think, where you see a statement in the terms and conditions that says you consent to service by email or whatever it might be, and whether that would count. I think the answer to that actually is probably no. Even though you may get through Section 176A, one would not get to the position where that counts as explicit request. Because in fact, the way that the pre-action protocol is phrased at paragraph 3.3 is that if the debtor has made an explicit request that correspondence should not be sent by post and has provided alternative contact details, ... Note that a condition in a creditor's standard terms does not constitute an explicit request. So we're not looking here about a permission to do something in a different way. We're looking at a request to say, do not send me a letter. And I'd have thought the sort of thing that might be being considered there is where the debtor lives with someone else and someone else might open their mail and it might cause them embarrassment or do some damage to them in some other way, and they prefer to have it sent to them by email or some other private means of communication. So I think the simple answer is, in some cases, there might be overlap with Section 176A, but in most cases, it's aimed at a different situation and it should really be sent by post.
Yes, I think I would agree with that. What is clear is that mere use of the terms or the general terms is not sufficient to comply with the protocol. However, if the creditor in question has taken a view that in order to comply with 176A, they've obtained explicit consent, for example, a please turn off paper statements, for example, or please turn off paper correspondence, depending on the exact wording of that, it might be that it falls within paragraph 3.3 of the protocol. One other question that we've had is, was there any need for this protocol given the already sufficient protections provided to debtors, for example, by the FCA?
Well, clearly someone thought there was a need for it somewhere in the bowels of the Ministry of Justice. I think in a lot of cases, probably 85% of cases, it's going to be very similar to what exists under the CCA or the FCA handbook. It really echoes a lot of the obligations, and if a creditor can comply with the FCA handbook and they can comply with sending default notices or complying with Section 77, 78, 79, this is just going to replicate that in a different form. Where it comes into its own is that, as I said, the CCA or the FCA handbook, regulated lending, is not necessarily coterminous with the scope of this protocol. There will be situations, for example, exempt agreements. They're not going to be covered by those sorts of things. They're not going to come within the FCA handbook, but they are going to be lending potentially from a business to an individual. It's worth bearing in mind that sole traders are covered by this. So if you're lending for business purposes over £25,000, for example, you're still going to have to comply with this, even though you don't have to comply with the Consumer Credit Act. So there are a limited number of circumstances, I suspect, but it is different in scope, and that absolutely has to be borne in mind. It can't just be thought of as a further part of the CCA.
And finally, Tom, we've had a question about whether the new pre-action protocol will result in fewer cases ending up in the courts.
Well, you're probably slightly better placed to answer this question than I am, actually. But I suspect the answer is probably no. I mean, creditors now with Conc 7 are well used to this sort of negotiation. They go through it, they send letters, they give every chance to settle or to come to a payment plan. And things that end up in court end up in court. I can't see an extra 30 days is going to make an enormous amount of difference.
No, I think that's absolutely right. And what I would say is the vast majority of cases, if we're just looking at a pure numbers game, that end up in court are undefended and end up in default judgment. And that means that effectively the debtor in question has not responded to the formal claim form and particulars of claim. If they've not responded to the formal claim form and particulars of claim, I very much doubt they would have responded to the pre-action protocol letter, in which case they'll ignore 2 letters instead of 1. And the creditor will still be entitled to judgment.
Yes.
Sorry, just check emails. No, I think that's it. So that brings us to the end of our questions and the end of our time. If you have any further questions about the new protocol, please feel free to send us an email or give us a call in Chambers. Thank you all for joining us this morning, and a special thank you to those who sent in questions. Our next interactive Gough Square live seminar from a financial services perspective is going to be scheduled for some time towards the end of September. We don't have an exact date for that now, but we'll send out details in due course. There is another Gough Square live seminar next Thursday. That's on consumer regulatory issue, going to be hosted by Michael Coley and Cameron Crowe on grey market goods and intellectual property rights. Please do send Jack in the Clerks Room an email if you'd like to be included in that broadcast. We hope to see you then, but for now, goodbye.